So, as police were asked to deal with youth in ways that didn't involve sending them directly to prison, the YCJA seems to have had some effect in actually convincing them to do this. If you look at this graph here, this is showing the gray line down the middle there is showing right when the YCJA came into effect. But even before then, you see that this line is already going down. And even though in 2003, it's right here where it came into effect, police were already getting the idea that okay, Parliament has passed this legislation that's going to come into effect soon, and the directive lines are asking us to deal with kids in ways other than formally charging them. And so the percentage of cases, like this percentage here is showing the percentage of cases where the police arrest the youth or stop the youth or are able to charge the youth, and the percentage, the line is showing how many of those cases the police actually file a charge versus just deal with the kid in some way that doesn't involve filing a charge, either by letting the case go or, as we see under the YCJA, giving them a warning, giving them a referral, sending them off to do something else. And so right around 2000, you see about 3 out of every 5 cases, 60%, is being dealt with by an actual charge. Whereas under the 2003 legislation, it dropped down to about 45%, which is right around where it's hovered since then. I mean, this only goes to 2014, but you see it's a very steady line in terms of police behavior being concretely affected by the YCJA. Even once these cases are handed off by the police to prosecutors, you see there's an even bigger drop-off. What this is showing is the absolute number of cases that once a kid can be charged, they're actually seeing their cases concluded in court. So the police are referring less people to the lawyers, and then you saw under the previous graph, you see this line stays flat over 2 decades. Once it gets in the hands of the lawyers also are dropping more cases and dealing with more cases extrajudicially. I mean, this graph is also going to be affected by other factors like demographic shifts, smaller numbers of young people. But still, you see that not only the police, but prosecutors are getting the message as well that Parliament wants other considerations to be brought in, other possibilities. So overall, people are starting to get the message, is jail the best way to deal with the problem for young kids who are acting criminally? The YCJA says, no, it isn't. So please implement that. You can subject them, if you're a judge who's sentencing them, we're not talking about police or prosecutors anymore. If you're a judge who's sentencing them, you can subject them to a supervision order, which is essentially a probation order, which will probably be more effective long term, right? That's going to involve somebody who's a youth supervision worker, essentially often they're the same as a probation officer, who will be steering the kid and keeping them in line, which is probably going to be more effective than just hammering them with a custody sentence. Even if a kid is sentenced to custody by a judge, and they don't call it prison because they want to avoid using the same language they would use for adults, if a kid is sentenced to custody, a judge who does sentence somebody to custody has to include a supervision order as part of it. That means you're required, if you're a young person, it's required that you be sentenced to some kind of probation. For adults, that's not the case. You can just be paroled, and when your prison sentence is over, it's over. For youth, you get your prison sentence, your custody sentence, but there is mandatorily a supervision order attached to it. Custody is really just meant to be for the cases where it's absolutely necessary. If there are serious violent offenses, sure, by all means, the public needs to be protected. If you've got a kid who's 15 years old committing aggravated assault, fine, sentence them to custody. And even if it's not a serious violent offense, if it's some situation where you have a kid who's being sentenced to supervision orders, essentially, again, probation orders, and 3-4 times as a youth they're shoplifting and they're getting these supervision sentences, then if they're showing a repeated pattern of not being able to comply with those, then a judge is allowed to resort to custody for them. But before a judge sentences any kid to custody, whether it be for a serious violent offense or for not complying with supervision sentences, a judge has to get a pre-sentence report. You might remember us talking earlier in the year about pre-sentence reports as being something that adults who are committing crimes for the first time, a judge might order a pre-sentence report to try and figure out what's going on with this person, that they're acting this way. For youth, it's mandatory. It's not just the judge is curious and wants to figure this person out. They have to absolutely inform themselves through a pre-sentence report as to the circumstances of this kid in a formal way. The result has been that it is true that you don't have the highest incarceration rate anymore. We still have overall in Canada on average about 15% of kids who are sentenced following a youth court case. If they're found guilty and they're sentenced, there's still about 15% of them who are sentenced to some form of custody. But you see in Quebec, it's below 10%, right? It looks like it's at 9%. I think this is from about 7 years ago, so this is old information, but still it's indicative that the incarceration rates aren't what they used to be, which is a good thing. That's what the Parliament was hoping to send home, not just the police, but the judges as well. Instead of custody, the judges have to do something with these kids, right? They have to come up with some sentence. We saw that supervision orders are a big part of it, but there's also formally in the YCJA, there's a lot more options than before, right? And this is Parliament thinking to itself, well, if we're going to ask judges to not just go ahead and send them to custody over and over, we need to give them other options to consider. And the YCJA gives a long list to judges of extrajudicial sanctions they're allowed to sentence kids to, right? And some of them, again, are things that wouldn't make sense necessarily for an adult, but they can force a kid to participate in a victim reconciliation program, right? Where they have to meet with the victim and explain and hear more from the victim, develop a little empathy as to the results, the consequences of their actions, right? Obviously, this would require a victim being willing to participate, so it's not going to be like the victim's forced to participate. But you could have cases also where the young person might be forced to perform personal service for the victim. I mentioned the example of cleaning up the shop that you vandalized, issuing an apology, right? This can, in some cases, this will mean nothing, but in some cases, this will have an important effect. Forcing the kid to contemplate and think about what they've said, either through writing an essay, or, as is often the case, if you're criminally involved, often your verbal skills aren't the best, so some sort of artwork or a poster to express your understanding that, yeah, I get it, I screwed up and this hurts people and I got to understand that. So all these options, the judge has all the traditional means at place to be able to punish kids through a supervision order, but they also have a range of extrajudicial sanctions that Parliament is asking them to consider applying in the case of any kid where custody doesn't have to be implemented. There's also this possibility of a reprimand. We saw that the police officer is allowed to caution somebody that they've arrested and then send them away. We've seen that the Crown is allowed to caution someone and say, hey, straighten up, next time you'll be in trouble. But the judge is also allowed to reprimand. I saw this in one case where the judge was pretty annoyed with the prosecution for bringing the case to in front of the court because the kid had stolen a chocolate bar. And the prosecution had thought about it, and they'd been dealing with this kid for a while, and they're frustrated with this kid. So they did actually consider not bringing the case to court, but this kid had been, committing multiple petty offenses. So they did bring it to court, but the judge wasn't happy. So the judge yelled at the kid in court and then said to the clerk, just write down, I give him a reprimand. It's allowed under the YCJA. Now get out of here. There's all these options that hadn't been in place before. Deferred custody and supervision order is kind of the equivalent of a conditional sentence of imprisonment. That's like house arrest for kids. So you can have house arrest jail in the house for kids. Non-residential programs where they're in custody without being in custody the way we would normally think. So this brings us to our original question, which, again, we go back to the moral panic. We're worried about young people committing murder. What actually happens now under the YCJA? Remember that the Young Offenders Act said 3 years maximum, so we had those 3 idiots who killed those 2 nice people in Beaconsfield, and they only got 3 years for it. If you're over 14 under the YCJA, you're still dealt with as a young person. But even though you're still in a separate building, you're dealt with by separate lawyers, separate judges, the prosecutor can ask for an adult sentence. Now, it used to be that if you were over a certain age under the Young Offenders Act, I can't remember if it was over 16, and you were charged with a serious violent offense, that they could then move your case to adult court. They don't do that anymore, because the thinking is if we move it to adult court without finding whether or not they're guilty, then it's sort of like goes against the presumption of innocence. We're dealing with these kids as if they've definitely committed this crime when we haven't made a legal finding that they have. So these cases still stay in youth court. But it is possible, if a prosecutor thinks that the sentence that the kid would get under the Youth Criminal Justice Act would not be sufficient, would not be appropriate, they can request that the judge administer an adult sentence. And this eligibility kicks in as soon as you're over 14. So all the sentences that adults would get, the lengths of sentences, the years of sentences, they can be asked for once you're over 14. Typically, this really only happens in very serious cases. Like if you're 16 and you murder someone, the prosecutor can request that you be punished as an adult, which means that if you're over 14, you commit a murder, it's very possible that you can get a life sentence with no possibility of parole for 25 years. And the judge is just supposed to ask herself, is this a situation where a youth sentence would be insufficient under the circumstances? In practice, this is pretty rare, again, because youth tend not to commit murder. Now, if you're under 14, they can't sentence you as an adult. That option isn't available. But there still are sentences in place that are more severe for serious offenses than they were under the Young Offenders Act. First-degree murder, even if you're 12 years old, can be punished by a 10-year custody and supervision order. Second-degree murder, that means you didn't plan it out ahead of time, but you did want to kill the person. 7 years is the maximum. And for other major offenses, the 3-year maximum that existed in the Young Offenders Act is there as well. But unless it's one of these really serious cases, then it's going to be a 2-year maximum for everything else. And of those 2 years, no more than 2/3 can be served in custody. They have to let you out after 2/3. Kind of like what exists with adults, but in a slightly different way. So Young Offenders Act was a blanket 3 years for anything, and we saw people get incarcerated a lot. The 3 years is not going to be available under the YCJA. It's 2 years is the blanket duration, but for really serious things, more serious sentences are available. And if you're above 14, you can be sentenced as an adult. Now, the last big question, what happens to your record? Like, people always want to know, do I still have a criminal record for things I did as a kid? It depends. If you've committed an offense as a young person, then your record is only accessible by a very limited number of people, but that includes judges. So if they're sentencing you, you do have a record. Newspapers aren't allowed to talk about you. They're allowed to talk about you, but they can't name you. They can't identify you in any way. Once you're sentenced as an adult, that changes, but generally before then, you can't be spoken of. You can't be named. Now, what happens is, if you commit a crime that's an indictable offense, then as a young person, it does exist on your record. But 5 years after you finish your sentence for your crime as a young person, it disappears from your record. And that's whether you're an adult or not. So let's say you're 12 years old. Well, no, let's say you're 15 years old. You commit a crime, and then you turn 18. So the crime you committed when you're 15 is still on your record because 5 years haven't gone by yet. But once you turn 20, that crime you committed when you're 15 disappears from your record and it's gone. Except if within those 5 years, like you've become an adult within those 5 years, and you commit a new crime as an adult within those 5 years, then your youth record becomes permanent. It stays on your adult record and it's on there forever. So now the thing you did when you're 15 is going to be on your adult record forever, unless you get essentially a pardon for that to go away. So that's the interplay. As long as you don't commit a crime as an adult, your youth crimes disappear. But once you do, if you do it within 5 years of the crime, then your sentence, then your record is going to keep that mention of what you did. So that's the Youth Criminal Justice Act. Get in touch with me if you have any questions about it, and that's it.